Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzelli & Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by DocketWise, an all-in-one immigration forms and case management solution trusted by thousands of immigration lawyers across the U.S. I really like DocketWise. It makes immigration applications easy by allowing the clients to provide information through simple online questionnaires that are shareable by text or email and available in multiple languages. Not only that, DocketWise provides a comprehensive group of case management features, including invoicing and calendaring, secure messaging, task management, and a lot more. You can learn all about DocketWise and receive a 10% discount on your subscription by heading to docketwise.com/immigration-review, so they know we sent you. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. Bunch of asylum-type decisions with one very important holding from the First Circuit that I'll take first. After that, I'll just go in circuit order. From the 1st to the 9th we go. Also, it looks like the 9th Circuit made some interesting law this week regarding special immigrant juvenile status adjudication delays with USCIS and the ability to bring class action immigration lawsuits in certain circumstances, notwithstanding the Supreme Court's decision last term in Garland v. Aleman-Gonzalez. That decision is Moreno-Galvez et al. V. Urjadu et al. Give it a read if you practice in that area, as I'm sure you would have regardless. 6 cases to discuss. Starting off with Laparra-Deleon v. Garland, published by the First Circuit on November 4th, 2022. This decision is about deficient notices to appear and in absentia motions to reopen. It must be, due to the name. Because, my friends, it is a direct petition for review of the BIA's decision last year in matter of Laparra. Mr. Laparra entered the United States without authorization in 2002, and he was served with an NTA in 2008. That NTA, however, did not contain the date and time of his first removal hearing in violation of INA Section 239A. He received a notice of hearing from the Boston Immigration Court nearly 2 years later, containing the information for his first hearing. Seems like Mr. Laparra, however, may or may not have moved during the delay because the hearing notice was returned to the court as undeliverable. He therefore did not show up for that hearing, and he was ordered removed in absentia. Years later, he moved to reopen that in absentia order, claiming that the immigration judge had never actually had jurisdiction, and that in the alternative, the in absentia removal order must be rescinded and reopened due to the NTA deficiencies. The reason for that latter argument, Mr. Laparra argued, are because INA Section 240B5A only allows a non-citizen to be ordered removed in absentia by an IJ for failing to attend removal proceedings, quote, after written notice required under paragraph 1 or 2 of Section 239 of the INA, end quote. Plus, Section 240B5C then provides that an order of removal in absentia may be rescinded if the non-citizen, quote, demonstrates that the non-citizen did not receive notice in accordance with paragraph 1 or 2 of Section 239A, end quote. So the argument goes, without a Section 239A compliant notice to appear, there is no proper notice, and so the non-citizen can't be ordered removed in absentia, and if an IJ did, or does, the removal order must be reopened and rescinded. The 9th Circuit, and to a lesser extent the 5th Circuit, have said just that. Singh and Rodriguez. The 11th Circuit, in contrast, says it doesn't care. I shan't utter the name. The BIA, in this very case, matter of Laparra, said a follow-up notice of hearing cures any problems and permits an in absentia order of removal. So where would the First Circuit fall in the dispute? Find out after this commercial break. Nah, I'm just kidding. But that tantalizing spot could be yours, potential sponsors. Oh, the possibilities. Back to the case. The First Circuit has sided with the Ninth Circuit, and in so doing has entered the circuit split on the side of non-citizens in New England and Puerto Rico. Not only that, but because this is a direct petition for review of matter of Laparra, and matter of Laparra is now being vacated, this makes matter of Laparra immigration review zombie precedent. Meaning, according to me and one recently appointed immigration judge, I simply do not see how matter of Laparra is good law anywhere, because the case itself does not exist. I'd personally be making that argument everywhere. That is, that there is no longer precedential BIA authority governing what to do with in absentia motions to reopen, premised on deficient NTAs. The reason explained the First Circuit lies in the statutory text itself. What I just read really is quite clear, and tethers both the in absentia removal order and rescinding it to an NTA as defined at INA Section 239A. And to the First Circuit, and if I may be so bold, anyone objectively reading the Supreme Court's precedent, Chavez and Pereira, and even though those cases of course regarded the stop time rule for non-LPR cancellation of removal, deep down, quote, each address that issue by determining what constitutes a notice to appear under Section 239A1, end quote. Chavez and Pereira are all about what is an NTA. And that is what the in absentia reopening statute turns upon as well, Section 239A1 and the definition of NTAs. To the First Circuit, the text and this precedent is clear. And that includes the very reason for why a follow-up notice of hearing can't save a deficient NTA in this context. INA Section 239A2 discusses notices of hearing, but it makes them applicable when hearings are changed. But you can't change a hearing, as that word is traditionally understood, if it was never set in the first place properly. Notices of hearing are kaput. The First Circuit cast aside Mr. Laparra's argument that the IJ didn't have jurisdiction, as every court has done, but granted the petition for review as to the challenge to the motion to rescind the in absentia removal order and the main holding of matter of Laparra. And so, congratulations Lydia M. Sanchez for petitioner, along with Christian McLeod Ball and Trina Realmoto on brief for the National Immigration Litigation Alliance, Political Asylum Immigration Representation Project, the American Immigration Lawyers Association, and the American Immigration Council on amicus. Everyone's here. As I said to a colleague as I was outlining this decision, matter of Laparra is dead. Long live deficient NTAs. And watch out for zombies. And that is Laparra-Deleon v. Garland. Next is Pinel-Gomez v. Garland, published by the Second Circuit on November 2nd, 2022. This decision is about corroboration. Mr. Pinel-Gomez and his minor son are asylum seekers from Honduras. They fear the Mara 18 gang due to death threats received when Mr. Pinel-Gomez refused their extortion demands, and because he reported them to law enforcement. Mr. Pinel-Gomez asserted that his refusal to comply with the gangs evinced an anti-gang political opinion, and that his cooperation against them with police made him part of a particular social group. He testified to all of this in immigration court, and even provided the police report from Honduras. He also submitted a corroborating letter from a friend who was himself hospitalized after a Mara 18 attack, and also country condition evidence on Honduras. To be honest, more evidence than in many cases. But the immigration judge concluded that it wasn't enough, and the BIA affirmed, both determined that Mr. Pinel-Gomez didn't meet his burden to obtain asylum. And in fairness, the IJ identified some reasons to doubt the veracity of some of the evidence. Before the Second Circuit, Mr. Pinel-Gomez asserted only that the BIA improperly deferred to the immigration judge's determination that more evidence was required, and that Mr. Pinel-Gomez should have and could have provided that evidence. So that's a wonky issue before the Second Circuit here. Standards of review. In the context of corroboration, of course. The INA is clear that asylum applicants, and really all applicants for relief in immigration court, can meet their burden based on their credible testimony alone. However, and especially after passage of the Real ID Act, quote, where the trier of fact determines that the applicant should provide evidence that corroborates otherwise credible testimony. Such evidence must be provided unless the applicant does not have the evidence and cannot reasonably obtain the evidence, end quote. IJs have wide latitude about what evidence they can desire and require. Then again, if an IJ requires corroboration, and in the Second Circuit at least, the IJ must 1, quote, point to specific pieces of missing evidence and show that it was reasonably available, 2, give the applicant an opportunity to explain the omission, and 3, assess any explanation given, end quote. So a desire for further corroboration by an IJ doesn't necessarily tank an asylum claim. It just kicks into gear a 3-point inquiry. Does that require a second hearing for the non-citizen to possibly obtain the requested evidence? It might in some circuits, like the Ninth Circuit, Wren v. Holder, but this decision isn't about that issue. If corroborating evidence is deemed necessary, and if it can't be obtained, and if the IJ believes it could reasonably have been obtained, the non-citizen loses. The main question in this case is, how does the BIA decide whether the IJ erred in this multi-pronged analysis? I told you it's a wonky one. But standards of review are kind of gotchas when challenging BIA decisions before the circuits, one might argue. So here it is from the Second Circuit. Quote, the IJ's initial determination that an applicant should provide corroborating evidence is not a factual finding. We therefore hold that the BIA reviews that determination de novo. The IJ's subsequent determination as to whether an applicant does not have the evidence and cannot reasonably obtain the evidence, i.e., as to the existence of circumstances that will excuse him from providing corroboration, is a factual finding that the BIA reviews only for clear error, end quote. In layman's terms, if that layman was an immigration attorney, the decision of whether a non-citizen warrants asylum based solely on his testimony is something the BIA is going to review without deferring to what the IJ decided. But if the testimony is deemed insufficient, whether the non-citizen should or could have provided more evidence is a factual inquiry that is only overturned if the IJ was clearly erroneous. That is, messed up bigly. Indeed, quote, what is reasonably available differs among societies and, given the widely varied and sometimes terrifying circumstances under which refugees flee their homelands, from one asylum seeker to the next, end quote. I tend to agree. But unfortunately for asylum seekers, and certainly Mr. Pinel-Gomez, that sounds a lot like a factual question to the Second Circuit, which means deferential standard of review. Because IJs, like trial judges everywhere, are in the best position to find facts. Not only that, to the court, whether an IJ does or does not believe additional evidence reasonably available comes down strongly to whether the non-citizen's explanation is believable, and that too is a, quote, quintessential factual determination, end quote. Having so held, the Second Circuit held further that in this case, the BIA properly applied de novo review to the first issue, and then properly applied the clear error standard to Mr. Pinel-Gomez's explanation of the unavailability of the evidence. And as a deferential finding, well, the Second Circuit didn't believe that it was required to overturn the BIA there. Mr. Pinel-Gomez and his minor son, therefore, lost their case. And that is Pinel-Gomez v. Garland. Moving on to Quituizaca v. Garland, published by the Second Circuit on November 1st, 2022. This decision is about nexus and asylum, and it broke my heart. It enters the circuit split about the nexus requirement for withholding of removal as compared to asylum, in favor of the BIA and unfriendly to non-citizens. Gong to come, alas, Second Circuit. Mr. Quituizaca is from Ecuador and entered the United States without inspection in 2006. Removal proceedings began in 2018, where he applied for asylum and related relief. His claims arise out of the fact that, quote, he was twice attacked by the Maracha Kiguas, a gang in Ecuador that he claims targeted him because of his indigenous Quechua ethnicity, end quote. On one occasion, the gang took him off a bus at knife point and beat him and robbed him. Looks like he was pro se, and some other of his testimony indicates that the gangs would routinely stop buses to rob the riders of the buses. On another occasion, the same gang got him at a bus stop at midnight and demanded his money and his clothes. His friend fought back and was stabbed to death. The gang threatened that Mr. Quituizaca and his family would, quote, meet the same fate, end quote, if they reported anything to police. So Mr. Quituizaca did not. He was then robbed many more times in 2005. But it looks like the reasons for why he was robbed may have been varied. His pro se testimony could have been more clear, which is why people hire attorneys in immigration and all areas of law if they can afford them. Now, persecution on account of ethnicity will qualify a non-citizen for asylum or withholding of removal. Ethnicity is one of the 5 protected grounds, although not discussed nearly as much as some of the others. But the immigration judge did not believe that Mr. Quituizaca's indigenous ethnicity was at least one central reason for the harm that he had suffered. The BIA agreed. Both held that Mr. Quituizaca needed to show that his ethnicity was one central reason for the persecution he suffered and feared to qualify for either asylum or withholding of removal. The thing is, though, that that's not what the withholding of removal statute actually says. That statute at INA Section 241b(3)(c) just requires that a protected ground be a reason for the harm suffered or feared. And Ms. Chavez teaches us that words like a and the can be very powerful things. Asylum requires one central reason, but not the withholding of removal statute. The BIA caught on to this madness 12 years ago in matter of CTL and said that Congress just wrote a confusing statute, but don't worry, it's the same nexus standard for asylum and withholding of removal. After all, withholding has a higher evidentiary burden, so it would be quite weird to permit a withholding of removal grant when asylum failed on the merits because of a lower nexus standard, said the BIA. The Ninth Circuit and the Sixth Circuit have said, no way, BIA. The withholding of removal statute says what it says. It's unambiguous. The statutory text only requires a reason, rather than the asylum one central reason. So yes, indeed, withholding has a lower nexus requirement. Mr. Quituizaca wanted the Second Circuit to agree, and he got what is surely excellent counsel for the petition for review stage. But the Second Circuit did not agree. Instead, the Second Circuit agreed with the BIA, a Third Circuit footnote, and if I'm being honest, a Fifth Circuit decision from last year, uncited in this decision. The asylum and the withholding of removal nexus standard is the same in the Second Circuit. The Second Circuit believed the statute ambiguous, and when that happens, it must defer to the BIA's reasonable interpretation of the statute, and that means matter of CTL. It was reasonable to the court, quote, applying the one central reason standard to withholding claims would thus avoid an internal contradiction in the act, end quote. Would hate to have one of those. The Second Circuit explained its statutory analysis in like 20 pages and then agreed with matter of CTL. True, said the Second Circuit. The nexus requirement isn't as high as a but-for causation standard applied in other areas of law. But a protected ground must be at least one central reason for the persecution suffered or feared to qualify for asylum or withholding. The only difference, of course, is that asylum has a lessened evidentiary burden. The non-citizen must only show a 10% likelihood of future persecution, as compared to the more likely than not 51% standard required for withholding. Turning then to the IJ and the BIA's denial of Mr. Quituizaca's claim, the Second Circuit saw no reversible error. Like the IJ and the BIA before it, the court believed that Mr. Quituizaca hadn't shown that his indigenous ethnicity, rather than gangs wanting money and terrorizing communities, was one central reason for the harms that he had suffered and feared. Even if they did call him a, quote, Indian, end quote, during an incident. The Second Circuit held that Mr. Quituizaca waived all other arguments, including his CAT claims, and so ruled against him. And that is Quituizaca v. Garland. Next is Madrid-Montoya v. Garland, published by the Fourth Circuit on October 31st, 2022. This case is similarly about asylum and nexus. Miss Madrid-Montoya is from Honduras. She and her daughter lived with her father's daughter for 5 years, a man named Jermaine. Jermaine had some land. In August 2013, local narco-traffickers from a Honduran gang told him to leave the area so they could use his land to run drug operations. He refused. They murdered him 5 days later. Fearing for her life and that of her young daughter, Miss Madrid-Montoya fled to her aunt's house 2 hours away. Turns out Jermaine wasn't the only one in town that this happened to. The gang was targeting all or many landowners in the area. In what appears to be quite honest and compelling to me, Miss Madrid-Montoya testified, quote, "You can't do anything there. The narco-traffickers don't allow you to put any cattle or anything in that property, so everybody's scared to do anything there," end quote. About 15 months after moving to her aunt's house, Miss Madrid-Montoya received a phone call from an unidentified man who, quote, said that this was in reference to the people that killed the father of my daughter and that I should leave the area, end quote. The caller told her that if she didn't leave, she'd suffer the same fate. She didn't report it because she thought it was pointless to do so. She fled to another family member's home 5 hours away, and she lived there for a few months, but fearing she'd eventually be found, she fled to the U.S. with her daughter. According to the court, Miss Madrid-Montoya has consistently explained, quote, when asked why the narco-traffickers would be interested in her and her daughter, "It was because they think that I'm going to go back and take over the property that belonged to my husband," end quote. She sought asylum in the U.S. based on her membership in the particular social group, quote, "Family of Germain Puentes Urbina," end quote. But the IJ and the BIA saw that this was more of a land dispute, holding that, quote, "the family relationship in this case has not been shown to be a reason for the claimed harm," end quote, i.e. a no-nexus holding. And the Fourth Circuit found no error in that. To satisfy the asylum nexus standard in the Fourth Circuit, the applicant need not prove that the protected ground in this case, membership in a particular social group, quote, was the central reason or even a dominant central reason for persecution. Although the protected ground must at least be more than an incidental, tangential, superficial, or subordinate reason, end quote. To the Fourth Circuit, the reason for the harm is a, quote, classical factual question, end quote. And factual questions are reviewed quite deferentially. In this case, Oil conceded that yes, indeed, the family of Germain Puentes Urbina is a valid particular social group. And even that Miss Madrid-Montoya was part of it, it appears. But just not that the threats and harms that she suffered and feared were on account of her membership in that group. To the Fourth Circuit, the BIA properly reviewed why Miss Madrid-Montoya and not someone else was targeted. And like the BIA, the Fourth Circuit agreed that, for example, the fact that the gangs targeted other landowners in the area showed that it wasn't on account of Miss Madrid-Montoya's relationship to Germain. It was more about the land. Or that is to say, while the evidence could support either conclusion, the BIA wasn't crazy to make the land-based finding rather than a family-based one. Remember, gotta fear death for the right reasons to avoid death under immigration law in the United States. Moreover, quote, that no one else in Germain's family has been threatened further supports the finding that petitioner's familial relationship to Germain was incidental or subordinate to her persecution, end quote. The Fourth Circuit distinguished quite a bit of recent non-citizen-friendly precedent and ruled against Miss Madrid-Montoya. Check out that precedent, though, all discussed over the last 2 years on the podcast. But in this case, Miss Madrid-Montoya did not succeed. But here are some additional ways to win a similar case in the Fourth Circuit. Quote, had the narco-traffickers threatened petitioner while Germain was alive in order to coerce him to give up his land to the narco-traffickers, the BIA might well have compelled to reach a different result, end quote. Or how about this? Quote, alternatively, had petitioner proffered proof that the narco-traffickers knew her daughter was the lawful owner of the land and thought petitioner was the pressure point for ensuring her daughter did not exercise her rights to the land, that too may have compelled the BIA to reach a different result, end quote. Under those circumstances, a land-based dispute can transform into a family-based persecution, and Miss Madrid-Montoya and her daughter could likely stay in the United States. And that is Madrid-Montoya v. Garland. Moving to the Eighth Circuit with Coreas-Chavez v. Garland, published on November 1st, 2022. This is a short case about asylum and motions to reconsider. Ms. Coreas-Chavez is actually the spouse of another petitioner here, Mr. Zelaya Chavez. They are from El Salvador, and Mr. Zelaya-Chavez was harassed and extorted by gangs due to his owning several businesses. Mr. Zelaya-Chavez let the gang members steal from him and paid them when necessary, including $130 in response to a note that said it was going to be bad if he didn't pay. But Mr. Zelaya-Chavez eventually had enough and reported it to police. As a result, police had him go undercover twice and identify the gang members. Members were later arrested, but then released. And later, quote, a group of 7 armed gangsters came to Mr. Zelaya-Chavez's house and threatened to kill him and his family if he reported them to the police, end quote. Mr. Zelaya-Chavez, his wife, and their daughter fled El Salvador shortly after that and applied for asylum in the United States. During their time in the U.S., the gang members have continued to threaten their remaining family in El Salvador and demand extortion, because that's what gangs do. The IJ didn't see an asylum claim, nor did the BIA. After the BIA ruled, though, Mr. Zelaya-Chavez and his family obtained a new attorney who filed what appears to be a timely motion to reconsider with the BIA, bringing lots more arguments. The BIA denied it. The Eighth Circuit saw no error in the denial. Or that is to say, the Eighth Circuit avoided it by going right to the merits of the appellate denial, as apparently, quote, petitioners failed to challenge a determinative issue, whether the Salvadoran government inflicted or acquiesced in petitioners' alleged persecution, end quote. It's a short case, but the Eighth Circuit wanted to go right to the merits and saw no asylum claim, so what was the point, said the Eighth Circuit, to the BIA reconsidering the issue and considering more evidence? Make sure you challenge everything on appeal. Mr. Zelaya-Chavez and his family, therefore, will not get another shot to bring their claim and bring more arguments. Also, looks like there's some collateral and terse stuff in this decision that the Eighth Circuit may use in the future to deny matter of Fernandes-type motions to remand based on deficient NTAs. Heads up in the Eighth. And that is Coreas-Chavez v. Garland. Rounding out the week, we have Fernandes v. Garland, published by the Ninth Circuit on October 31st, 2022. This case is about particularly serious crimes and Convention Against Torture protection. Mr. Fernandes is from Mexico and was brought to the United States at 8 months old in 1991. His family did not have authorization to do so, and he grew up his entire life in the United States, California to be specific. Tragically, he developed schizophrenia with paranoid delusions and hallucinations as a child. Unlike most people with this disorder who grew up in the United States, Mr. Fernandes is not a U.S. citizen. And in 2002, he was convicted in California State Court of assault with a deadly weapon and sentenced to 240 days in jail with 3 years of probation. He was ordered removed and physically removed to Mexico after serving his sentence. He re-entered and was removed again in 2015. He re-entered again and was arrested for resisting a peace officer and possession of a controlled substance. Looks like DHS never reinstated his initial removal order, as DHS has authority not to do as a matter of discretion, and he was placed into removal proceedings a third time. In those proceedings, he applied for asylum and related relief, bringing claims based on his mental illness and the fact that he is a, quote, bisexual, end quote. He was provided an attorney based on his schizophrenia due to a policy implemented by the Obama administration. He testified as best as someone with schizophrenia and delusions can do in immigration court, and he was found credible. He testified to homelessness and his inability to secure needed medications in Mexico. He testified to multiple violent assaults in Tijuana, including an attempted rape and multiple sexual assaults. It appears much of this, if not all of it, was experienced during his homelessness. He also testified to multiple incidents where police beat him up in Tijuana. An immigration judge denied relief and protection. Most pertinently, the IJ denied asylum and withholding of removal by finding that the assault with a deadly weapon was a particularly serious crime. Based on an I-213 submitted by DHS, the conviction was a result of Mr. Fernandez's attempt to, quote, stab the victim with a knife multiple times, end quote. The IJ denied cat protection on the merits, and the BIA affirmed. In this case, the Ninth Circuit upheld the IJ and the BIA. First, particularly serious crimes. An aggravated felony is a particularly serious crime for asylum, and an aggravated felony or ag-fels with 5 years imprisonment in the aggregate is a particularly serious crime for withholding of removal purposes. But Mr. Hernandez's crime isn't an aggravated felony. The only potential ag fel would be at INA Section 11843F, a crime of violence, but that aggravated felony requires a term of imprisonment of at least 1 year, and Mr. Hernandez only got 240 days. One hurdle gone. But an IJ can always find a crime particularly serious based on the three-factor matter of NAM and matter of Frantescu analyses. And crimes that involve violence or a risk of violence are historically of the type. And that hurdle Mr. Hernandez could not overcome. His arguments were a bit limited because of jurisdictional problems that might have arisen if he had challenged the IJ's straight discretionary finding. So Mr. Hernandez first argued before the Ninth that the IJ erred in relying on the I-213 and that attempted stabbing stuff. An I-213 is kind of like an immigration police report created by DHS. But unlike police reports in criminal cases, there's a whole host of case law deeming I-213s inherently reliable. And perhaps more importantly, Mr. Hernandez never challenged the document's admission before the immigration court or contested what it said factually. Intelligently, Mr. Hernandez argued that the I-213 made proceedings fundamentally unfair because DHS never presented the officer who created it to testify. Mr. Hernandez relied on Alcaraz-Enriquez v. Garland for that argument, episode 73, where the Ninth Circuit held that indeed, quote, the immigration judge had violated due process in relying on a probation report over the non-citizen's objection, end quote. What a case that was in the Ninth. Quote, but a key fact in that case was that the non-citizen contested the information in the report, end quote. Remember that one, everybody. Not the case here. The Ninth Circuit also held that it was not error for the IJ, in this case, to weigh other aspects of the conviction and not deem the particularly serious crime analysis governed solely by the relatively low imprisonment sentence that Mr. Hernandez received. Having upheld the particularly serious crime finding, that left only cat protection. And Mr. Hernandez credibly testified to a litany of police beatings in Tijuana. Quote, 1. An officer punched him once in the stomach. 2. An officer hit him in the legs with a large stick. 3. An undercover officer cut his hair and groped him. And 4. Officers took him to the desert, kicked him, and forced him to walk home. End quote. But to the Ninth Circuit, quote, those incidents do not constitute torture. End quote. Now, rape is torture. And there is other case law unmentioned in this decision that strongly supports a finding that attempted rape is also torture. Carr v. Wilkinson, episode 40. But here, the quote, attackers were private actors, and substantial evidence supports the board's conclusion that Mr. Hernandez has not shown government acquiescence, end quote, at least with the attempted rape. You need the government connection to satisfy the cat. Plus, actually, it seems that police eventually broke up the attempted rape on at least one occasion. Nor did the BIA err in determining in this case that the country condition evidence doesn't show widespread torture of bisexual or mentally ill individuals in Mexico. True. Even if some of the alleged things a non-citizen fears are not more likely than not to occur in and of themselves, quote, the probability that at least one of event A or event B will occur could be sufficient to satisfy the more likely than not standard, end quote. So that's a pretty non-citizen-friendly cat aggregation standard in the Ninth. Still unmet here, though, notwithstanding the various feared harms for Mr. Hernandez. So Mr. Hernandez lost what appears to be a very well-researched and prepared petition for review brief. And while it would appear to post-date briefing, there is this before we go. No mention in this case of matter of BZR, published by the Attorney General this year, whereby Attorney General Garland vacated matter of GGS, which wasn't good law in the Ninth Circuit anyway, and permitted IJs to consider the non-citizen's mental health in the particularly serious crime analysis. That is, even with a really bad crime, it might not indicate that a non-citizen like Mr. Hernandez is a danger to the United States in light of his or her mental health and the possibility that the non-citizen can control it with medications. No mention of any of that in this decision. I'd say failure by the IJ or the BIA to consider this might be legal error for the Ninth Circuit to review, if indeed that is what occurred. For the next one. And that is Hernandez v. Garland. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review, or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate for 5 credit hours, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all. And follow the show on Instagram and Facebook at Immigration Review, and send us a tweet at ImReview. That's IMM Review. I'll be back next Monday for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.